Hello everyone, myself Nitu Singh, Assistant Professor of Indraprastha Law College. So in this class, that is BA-LLB 10th SEM, the topic is independence of judiciary. So let's start with the topic. Independence of judiciary. Basically, when we are talking about some history, the USA has adopted a system of separation of powers to ensure the independence of the judiciary. But in constitutional systems based on the concept of parliamentary sovereignty, the adoption of separation of powers is ruled out. And this is the case in England, and this is also partially the case in India. For in India, the doctrines of parliamentary and constitutional sovereignty are blended together. The meaning of independence of judiciary is the independence of the exercise of the functions by the judges in an unbiased manner, as in free from any external force. Correct? So what I said, the meaning of independence of the judiciary is the independence of the exercise of the functions by the judges in an unbiased manner, as in free from any external force. Okay, this is the meaning of the independence of judiciary. So why we need the independence of the judiciary? Need for the independence of the judiciary. These are the basic things we must know to check the functioning of the organs, exactly interpreting the provisions of the constitution to act in a fair and unbiased manner. This is the need of the judiciary, independent judiciary, sorry. And what is the importance of independence of judiciary? Why we need this independence? क्यों हमें ज़रूरत होती है? तो मैंने आपको भी बताया what is the basic meaning of this independence of judiciary. So the independence of judiciary is still not clear after years of its existence. Our constitution, by the way of the provisions, just talks of the independence of the judiciary, but it is not well defined what actually is the independence of the judiciary. Correct है, मतलब आपको limitations दे दी गई, meanings दे दी गई, but अगर मैं बोलूँ कि दैट इज वो 100% से उसकी लिमिटेशंस क्लियर हैं, तो दैट इज नॉट ट्रू. And the primary talk on the independence of the judiciary is based on the doctrine of separation of powers, which talks of the independence of the judiciary as an institution from the executive and the legislature. So a place of justice is a hallowed place, and therefore not only the bench but also the foot space and presence and purpose thereof ought to be preserved without scandal and corruption. Francis Bacon ने बोला है ये. And independence of judiciary is indispensable in democratic system of government. Where the constitution contains the welfare philosophy, there the government has to make policies for the socio-economic development of the people. So in such type of functioning, government may at times abuse the political power, and in this way an independent judicial system was considered for the smooth functioning of democracy. And all the leading democracies of the world emphasizes this need time and again. Okay, so the genesis of institutional independence we found in the theory of separation of powers, which is stress for functional independence, but the independence of the individual judges depends on the provisions of the constitution pertaining to their appointment, conditions of services, transfers, benefits and security of tenure. So जो कंसेप्ट है इंडिपेंडेंस ऑफ जुडिशरी का, जो नीड है, जो इम्पोर्टेंस है, हम अंडरस्टैंड करते हैं. मीन्स जनरल सेंस की बात है. ऑब्वियसली जुडिशरी की जो अहम भूमिका है, तो उसके लिए उसे इंडिपेंडेंट होना या उसकी फंक्शनिंग जिस तरीके की है, उसके लिए उसका इंडिपेंडेंट रहना मस्ट है. So the concept of independence of judiciary is what? The concept of independence of judiciary is of modern origin and accepted as a hallmark of a liberal democratic state. But the term independence has neither been defined in the Constitution of India nor in the General Clauses Act. ओके हमने बोल तो दिया इंडिपेंडेंस ऑफ जुडिशरी, बट एग्जैक्ट डेफिनेशन क्या है जिससे कि क्लैरिफिकेशन बनी रहे, वो नो बडी नोज. एंड अ डिक्शनरी मीनिंग अगर आप लेकर के चलेंगे तो देर आर सो मेनी मीनिंग्स. एंड और अगर मैं आपको बोलूँ जुडिशरी मीन द पावर ऑफ अपहोल्डिंग इंडिपेंडेंस ऑफ जुडिशरी मीन्स द पावर ऑफ अपहोल्डिंग विदाउट फियर और फेवर एंड द रूल ऑफ लॉ, पर्सनल फ्रीडम एंड लिबर्टी, इक्वालिटी बिफोर लॉ एंड इम्पार्शियल एंड इफेक्टिव जुडिशियल कंट्रोल ओवर एडमिनिस्ट्रेटिव एंड एग्जीक्यूटिव एक्शंस ऑफ द गवर्नमेंट. दीज आर द जनरल मीनिंग जो इंडिपेंडेंस ऑफ जुडिशरी की निकल करके आएगी. बट अगर हम बोलें कि हमने अगर एक ये सिद्धांत दिया है, एक ये रूल बनाया है, एक नॉर्म दिया है, तो उसका अगर आपको एक्सप्लेनेशन आप ढूंढने चलोगे तो आप यू कांट फाइंड दिस. Okay, so the judicial organ of the state should not be in a position of subordination to another organ or branch. In this sense, the independence of judiciary depends on the power of the courts and allowed to be exercised without executive interference, and the judiciary has to be free from the control and subordination of the executive as well as the legislature. We have three bodies, these are executive, legislature and judiciary. तो judiciary supreme है और उसको आपको independent रखना है executive और legislative दोनों ही bodies से. So judges should be independent and free from any restrictions. ठीक है, नॉट ओनली दिस, जजेस मस्ट बी इंडिपेंडेंट एंड फ्री ऑफ देयर कलीग्स एंड superiors in discharge of their judicial functions. They must be free from two judicial functions. They must be free to discharge their duties and functions without किसी भी hindrance के. ठीक है, अपनी ड्यूटीज और फंक्शंस को डिस्चार्ज करने के लिए they must be free. And the responsibility of a judge to constitutional and legal norms forms from the foundation and the real rationale for judicial independence and independent judiciary is the sign of a perfect democratic system. Only an impartial and independent judiciary can stand as a bulwark for the protection of the rights of the individual and meet our even-handed justice without fear and favor. Okay, so for rule of law to prevail, judicial independence is of prime necessity. The independence of judiciary is normally assured through the Constitution of India, but it may also be assured through the legislation, suitable norms and practices. ठीक है, it means what I want to say कि independence of judiciary एक ऐसा part है जिसे ना केवल बस हमने बता दिया इसलिए उसे सिक्योर रखने की जरूरत नहीं. हमारे जितनी भी बॉडीज हैं, लेजिस्लेटिव, एग्जीक्यूटिव, सभी को इसको इंडिपेंडेंट बनाए रखने के लिए कंटिन्यूटी में एफर्ट करना ज़रूरी है, क्योंकि हमारी ये इट्स अ वेरी इंपॉर्टेंट पार्ट इन इंडिया. द क्वेश्चन ऑफ इंडिपेंडेंस ऑफ जुडिशरी हैज़ बीन अ सब्जेक्ट ऑफ heated national debate over the last many years. This question assumes great importance whenever the Supreme Court holds a particular act or a particular clause of an act passed by Parliament ultra vires of the Constitution of India. So, when we are talking about, मतलब ये तो मैंने आपको बताया कि होता क्या है, होना किस तरीके से चाहिए, बट इंडिया में क्या सिचुएशन है. So, the independence of judiciary is not be determined in all its ramifications as some a priority concept, but it has to be determined within the framework of the Constitution. Okay, so a notable feature of the Constitution of India is that it accords a dignified and crucial position to the judiciary in India, and the existence of a fearless and independence of judiciary is thus founded in the constitutional structure in India. And democracy, you can say there's sovereignty gains social reality and dynamic viability only of the constitution instrumentally submits to the board oversight of the sovereign people, but the people in general obviously cannot exercise monitoring, controlling, disciplining, and perform the like function. Exactly. So in this democratic setup now, the judiciary is an impartial umpire that resolves disputes within the boundaries laid down by a written constitution, and distribution of constitutional powers between different organs, namely parliament, state legislative and executive. So an independent judiciary is accepted by every citizen of the country, and is not only a fundamental right, but it is also a part of the basic structure of the constitution of India. So independence of judiciary is one of the basic structures of the constitution of India.